Alright, guys. Right from the opening seconds, you can feel the courtroom energy setting the tone. The judge wastes no time addressing the situation, subtly calling out the tension that arises when legal limits are pushed. What makes this moment compelling is how quickly authority is asserted and a decision is delivered without hesitation. An adjournment might sound routine, but here it signals something deeper: strategy, delay, or preparation behind the scenes. The judge's control is firm, calm, and unquestioned. In just a few seconds, we see how the courtroom operates like a machine. Every word carries weight, and every ruling shifts momentum. This is not chaos, it's controlled power in motion. And just like that, the stage is set for everything that follows.
It's the problem when you tell lawyers they can't do something. Anyway, so the parties are requesting an adjournment of the preliminary examination. The court will find, based upon the conversation at the bench, that there's good cause to do so. So I will adjourn the preliminary exam.
Guys, because this segment brings a mix of tension, unpredictability, and subtle courtroom drama. A case begins normally, but suddenly the absence of a key witness changes everything. Just like that, a charge is dismissed, reminding us how fragile a case can be without proper support. But it doesn't stop there. The defendant pushes back on scheduling, creating a rare moment where the court structure meets personal conflict. The judge's reaction blends authority with a hint of sarcasm, showing personality beneath the robe. It's these small exchanges that make the moment feel real and unscripted. Justice here isn't just about laws. It's about timing, presence, and pressure. And in this moment, one missing piece reshapes the entire outcome.
Examination that will be adjourned to May 19th, 2026. And be 28.
Thank you so much, Your Honor.
Thank you, Your Honor. Court calls case People versus Calvin Cannon.
Good morning, Your Honor. Raise hand on, please.
Good morning, Your Honor. Deborah Schlossel on behalf of the defendant, Calvin Cannon. State your name.
Calvin Cannon. Thank you.
Ma'am,
you don't have to take the baby out. That is fine. That is fine. In the bit, I don't understand Sussel, but okay. What are we doing?
Your Honor, this is the case dating time scheduled for preliminary examination in this matter. So unable to proceed on count 1 without further subject on count 2 with the items.
Your Honor, at this time, we would ask this matter be dismissed without prejudice since the exam was set for today and the witness has not shown up.
I will dismiss as to count 1. Count 2, I'll continue to defendant's not guilty plea. I'll set that for pretrial
May 4th at 9 a.m.
May 4th, 2026, 9 a.m. That's before Judge Washington.
Your Honor, that is a bad morning for me. Is there any way this could be another date, please?
No. Well, can be another date, but
I have to
talk
ask
to
her.
Washington.
Okay.
Worried about that.
All right.
I only have one date. I do have an in custody date. What's my in custody date?
It's April 20th at 9 a.m.
Oh, that's a good day for me. Thank you.
Of course it would be. What was that, April 20th at 9? All right, I'll set it for April 20th, 2029
Your Honor.
for Judge Washington.
This is where the courtroom slows down and the weight of the law truly settles in. What starts as a routine proceeding turns into a defining moment as the defendant agrees to a plea deal. Every right is carefully explained, every consequence laid out, leaving no room for confusion. Then comes the turning point, the admission. Passing a counterfeit bill may sound minor, but in this setting, it carries real consequences. What stands out is the calm, almost procedural way such a serious decision unfolds. No drama, no theatrics, just accountability. The judge ensures everything is voluntary, reinforcing the fairness of the system. This is justice in its most methodical form, where one decision quietly alters the course of someone's future.
Thank you.
Wilkin, you're welcome. Court calls the case, People versus Donovan Jankowski.
Motion to call this for the people.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Donovan Gronkowski. It's approaching. Did you say your name for the court?
Donovan Gronkowski.
All right, I have before me a form that indicates that the defendant will be pleading to an added count for false pretenses under $200. That's a 93-day offense. Upon a successful plea to that charge, counts 1, 2, and 3 would be dismissed. Defendant is agreeing to 24 months probation. That's court's full understanding of the.
That is correct. The recitation, Your Honor.
Yes, Your Honor. Thank you.
I have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the true self you got? Thank you, please.
Donovan Isaac Gronkowski.
Sir, it is this court's understanding that you're going to be pleading charge of false pretenses under $200. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour at 14A3 District Court.
Yes, sir.
Do wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. You'll see a copy. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on this.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
You on probation or parole?
No.
Is it promise other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce?
No.
Doing this voluntarily
Yes.
of your own free will,
Sir.
and also because you believe that you're indeed guilty of this offense?
Yes.
Date of June 23rd, 2025. Location of South Main Street near Commerce Park Drive in the city of Chelsea, Washtenaw County, state of Michigan. What do you do makes you think that you're guilty?
I passed off a counterfeit bill.
All right. And that was at some business?
Yes.
All right. And so you passed a counterfeit bill to get goods or services?
Yes, I paid for some groceries with a counterfeit bill.
Okay. Sir, I do have to advise you that if you commit misconduct as defined under the Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, that you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Counsel, are you aware of any of the promises, threats, or other inducements which have led to this?
No, Your Honor.
No, Your Honor.
Have I complied with the court?
Of course, that's fine.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 4. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
At 9 a.m.
May 18, 2026, 9 a.m. before Judge Freshour. And we'll continue.
Thank you, Your Honor.
Court does call the case of the People versus.
Now the pace picks up again, and the courtroom feels almost unpredictable. Case after case is called, and one thing becomes clear: the system doesn't wait for anyone unprepared. When the prosecution fails to proceed, dismissals come swiftly, almost effortlessly. It's a powerful reminder that readiness is everything in court. But what makes this segment stand out is the human side that slips through. Conversations feel less rigid, the judge shows personality, and there's a sense of familiarity in the room. Then suddenly, another case brings things back to focus with a request for more time, hinting at negotiations happening behind closed doors. It's a constant shift between formality and reality, showing that the courtroom is as human as it is procedural.
Abdul Latif.
Assistant Public Defender, on behalf of Mr. Abdul Latif, who stands to my right. Sir, would you please state your name for the record?
So Aziz Abdul Latif.
Your Honor, this morning, for prelim, excuse me, I am unable to proceed.
Defense moves to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice on the motion.
Thank you.
Thanks, y'all. I'll try to call you.
Why did you change the order?
I get you.
Fine. Court calls the case. People versus Rayshawn Ellis.
Ashley Feltus for the people.
Assistant Public Defender, Chinaki acting ruler, Your Honor, on behalf of Mr. Rayshawn Ellis, who's approaching. Rayshawn, state your name for the.
How come she went next first? Did not come over to see me.
I saw
Her around trying to figure out where she was.
Ann Judge.
And then all of a sudden shows up here. Like, you know what I mean? Yeah. Now probably wants a favor or something. Nope.
It's so good to see you.
Yes. As it is you, finally.
Thank you. Rayshawn, state your name for the record, please.
Rayshawn.
Thank you. All right, what are we doing?
It's better that people are unable to proceed.
We do move for a dismissal, Your Honor.
If it weren't for him, I so much don't want to grant. People being unable to proceed. This case is dismissed on defendant. Thank you.
You Judge.
You're welcome. Court calls case People versus Devian Morgan.
The Feltus for the people.
Good morning, Your Honor. Justin Zade appearing on behalf of Ms. Morgan, present stand to my right.
Devion Morgan.
Thank you.
Your Honor, we just had this morning for a preliminary examination, the people would have been able to proceed to examination. Conversations this morning, he's hoping we may be able to reach a resolution and I'm ready to get there this morning. We are respectfully requesting our time to have that conversation before we allow.
That's an accurate recitation of where we stand as of now, Your Honor. We share that request.
Two. That
I know.
I don't do that. How much time did you need?
We get about 4 to 5 weeks, Your Honor.
I have the 28th and May 19th.
I don't know that the 28th will be announced.
May 19th works for us, Your Honor.
Preliminary examination will be adjourned May 19th, 2026, 9 a.m. before me.
Thank you, Your Honor.
Thank you very much, Your Honor.
On continue. Thank you. You know, it's Valtez. She talked me into 2. Are we ready? This one.
Yes, sir.
Court calls the case People versus Jerome Adams.
Morning, Your Honor.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Adams.
My last one.
Yeah, that's for this one.
Oh,
State your name, Jerome.
Oh, Jerome Adams.
That's line right.
Your Honor, this is the daytime for preliminary examination. We're mentioning use the form via waiver. There's a few things for the record. That waiver is with understanding that will not add a larceny in buildings, as well as to additional strangulation or assault, but intent to do great bodily harm. In this case, we also will dismiss the half 4 that's on this case. Currently, we're going to continue negotiating on the matter.
okay.
Your Honor, my client has signed a waiver form. I do believe he wishes to waive his right to an exam. With respect to the 4th notice, I'm not sure that one was filed, but the people indicated they would not add.
Sir, waiving your right to a preliminary examination.
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Correct.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
You'll also waive the right. Preliminary examination having been waived, defendants bound over on count one with 2 following.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute.
Defendant having waived formal reading, standing mute to both charges, court will enter a not guilty plea. Pretrial will be set for
April 23rd at 1:30 with Judge Slay.
April 23rd, 2026, 1:30 before Judge Slay.
If I may bring up something as I guess a bit of a warning to the defendant. We've received information that his family members have contacted the victim in this case, asked her to put money towards his bond from the hearing. That is obviously it's a violation. Expecting anybody to do that, it's fully inappropriate in general. So just as a warning, did not be happening.
Your Honor, I believe my client understands the provisions of the no contact order. I'll remind him moving forward, certainly not to have any contact directly or indirectly with the complaining witness in this matter.
You understand that, sir?
Oh, yes.
Pardon?
Yes, sir. Yes, Your Honor.
All right. So talk to your family members. You'd probably need to let them know that if that kind of behavior continues, you're the one that's going to pay the price for that.
Honestly, yeah, I understand. I made that clear because she was calling, asking about some stuff that was left in her house.
Hold on. Don't
I told her not to.
know.
I'm sorry.
Yeah, I'm just saying,
Don't talk to her. No.
your standpoint, you need to let your family.
Yeah, I already told him. Don't talk to her.
All right.
I got
All right. Thank you. Bond will continue.
Thank you, Your Honor.
Defendant. Get to the podium, state your name, please.
Andrew Jacob Tolder.
Waiving.
Yes, there should be a written waiver in the file.
Sir, you're waiving your right to a preliminary examination.
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count one with 2 follow.
Your Honor, my client and I acknowledge receipt of a copy of the information. We waive its further reading. My client stands mute, asked that a not guilty plea be entered.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial in this matter set.
June 2nd at 1:30 with Judge Conley.
June 2nd, 2026, 1:30.
Thank you, Your Honor.
Feel
Okay, so
Bond can keep on going. Keep on going. What's he?
I don't know, but this is file.
What? I was just asking a question. You were up to something because you took offense at me, like pointing you out. Keep an eye on him.
May I approach to sign that information, Your Honor?
Sure.
bound over.
You're bound over. Yeah. I can't do it. All right. For this call the case.
The courtroom moves beyond decisions and into consequences. A defendant waives key rights, pushing the case forward, but the real moment hits when the judge issues a serious warning about violating a no-contact order. It's not just legal advice. It's a clear line that cannot be crossed. The weight of responsibility shifts directly onto the defendant. As more rulings follow, including dismissals of major charges, the balance between risk and relief becomes evident. Yet, the segment closes with a lighter tone, reminding us that even in serious environments, human moments exist. It's a perfect ending that blends tension, resolution, and reality.
Versus Matthew Gale. Oh, this is what he's up to.
I was preparing for
What?
the upcoming jokes, but
What upcoming joke?
John, every Assistant Prosecuting Attorney left the UK.
Good morning.
and Your Honor, 6'3" Joe Simon on behalf of Gail.
Client's like 8 feet.
Go ahead, Matthew Gale.
Your Honor, this is
It is cute, though. Okay, man, never mind, go ahead.
I'm scheduled for preliminary examination of this matter. Your Honor, at this point, we're unable to solve it. Now, we accept it. If you're demanding this report on the misdemeanor count.
Move to dismiss the felony counts, Your Honor.
So 1 through 3.
Yes, Your Honor.
Counts 1 through 3, 1, 2, and 3 are dismissed. I'll continue the defendant's not guilty plea as to count 4. Set a pretrial in this matter for
April 23rd at 10:30.
April 23rd, 2026, 1:30? 10:30.
I think I'm only saying this because this happened to me just yesterday. I think he does these at 1 o'clock now. Judge Fresh Hour. I'm okay, 10:30.
Hang on a second. Thank you for playing that out, Mr. Simon.
Thank you, Your Honor.
What do we have? Hang on, we'll check for you. Just for you.
1 p.m. It's a conspiracy.
We're involved in one yesterday.
I learned that because they were. Thank you, Your Honor.
Bye.
Well, they were wondering why things kept getting set on the DV docket different than that time because I had one this week that was errantly set. So that's the only reason I mentioned it. But thank you, Your
That's
Honor.
if they give us.
I know it was their old time and they've kind of like quietly changed it and not really told everybody. So
Yep, nothing like communication. All right. Thank you, Bob.
thank you, Your Honor. What